Bail application of the leader of the Enlightened Christian Church, Christian Gathering Church, Shepherd Bushiri, his wife Mary, and 3 co-accused has resumed in the Pretoria Magistrate Court. These are live visuals. Let's take you there now.
To board an international flight on the 17th of October 2020. It is of importance to state that the warrants of arrest for applicant 2 to 4 were obtained based on the fact that a prospect of a successful prosecution of all main suspects will be in jeopardy should one or more of them evade arrest. I refer there to page 11 of Exhibit M, Your Worship. Paragraph 4. It is with this knowledge at hand that the attorney of record for applicant 1 and 2, Mr. Victor Nkwashu, were telephonically contacted on Monday, the 19th of October 2020. Last mentioned were requested to present his clients no later than 11 o'clock that morning on the 20th of October 2020, and in lieu thereof, the warrants for their arrest would summarily be executed. The next morning, a message from Mr. Nkwashu indicated that Mr. Matopo is the lead attorney and will make contact with the investigator. The communication, SABC and legal representatives led the SABC to believe that the rest of main suspects might evade arrest whilst negotiating for an attorney and or advocate are ongoing. It is also important to note that the legality of the warrants, the applicant's arrest and the sequential detention is not in dispute. C. The bail application, paragraph 5. In terms of section 60(11) subsection B, the applicants have to adduce evidence which satisfies the court that it's in the interest of justice to permit their release. The question at hand is whether the applicants were successful in doing so. Paragraph 6. The applicants submitted sworn affidavits wherein each made vague declarations of denial to the allegations levelled against them. And unlike the dictum in S v. Mohammed 1999 to SACR 507C, the applicants did not establish a defence which has reasonable prospects of success at trial and should a mere denial not be regarded as a factor to support bail. Paragraph 7.1. Applicant 4 declared that she resides at 158 Empire Place, Sandhurst. This property is registered in the name of accused number 1, whom is currently declared a prohibited person by Department of Home Affairs. This property is, however, attached with a writ of execution, vide case number 2271 of 2020, handed down by the High Court, Gauteng Local Division. The respondent will argue that debt-ridden property can easily be abandoned and does not give credence to the applicant's bid in obtaining bail. It is the respondent's submission that the residential address supplied for the 4th applicant on its own does not support a finding in favour of this application. 7.2. Applicant 1 and 2 supplied the court with a deed to ERF number 1585, that's 48 Lake Circle, Midfield Estate, Midstream. It is the respondent's submission that a deed to a property does not guarantee such a holder's intention to stand his or her trial. Furthermore, the Sparkling Waters Hotel should not be regarded as a favourable factor in the bail application, as both applicants are held liable for debt to the amount of 202,5,044,845 Rand and 81 cents. Paragraph 7.3. The applicant, number 3, supplied the court with deeds to 2 properties, but it is my humble submission that both are in different provinces and none are monitorable for the purpose of bail conditions. The content of Annexure JM3 to Exhibit M should bear weight in the court's decision. The respondent will make available the officer who confirmed this affidavit. And I confirm, Your Worship, that he is today at court. And if the court wishes to call him. Paragraph 8. Where an accused carries the burden of proof on account of the provisions of section 60 subsection 11, in brackets, it is insufficient for an accused who wishes to rely on the weakness of the state's case to simply show that the state's case is weak. The accused must go further, i.e. show that the case is exceptionally weak, and this must be done by showing on a balance of probabilities that he will be acquitted. That's from S v. Masibuko and another, 2010, 1 SACR 433 KZB at page 23. The emphasis there is my own. And that is also found in the Toy Commentary on the Criminal Procedure Act 2019 at 9-40. Paragraph 8.1. The applicants, that is 1 to 4, did not contest the strength of the state's case. Safe to say that they deny the allegations against them. 8.2. Counsel for the applicants 1 to 3 argue that the charge sheet is bold and vague. Counsel for all 4 applicants, respectively, also made submissions to the effect that the state did not attach bank statements, details of complainants, or other evidence to substantiate the allegations. This submission, however, does not muster the burden of proof as set out in Section 60, subsection 11b, especially if the provisions of Section 60, subsection 40 is adhered to. Paragraph 8.3. The provisions of Section 60, subsection 40 reads as follows. Notwithstanding anything to the contrary contained in any law, no accused shall, for the purpose of bail proceedings, have access to any information, record, or document relating to the offence in question, which is contained in or forms part of a police docket, including any information, record, or document which is held by any police official charged with the investigation in question, unless the prosecutor otherwise directs, close brackets. Paragraph 8.4. Krigler J. said the following concerning access to the case docket in bail application in S v. Dlamini, 1999, to SICR 51, Constitutional Court judgment at page 82, in brackets. Nothing that was said in Shabalala should lead anything to believe that the defense is entitled to look over the prosecution's shoulder as the investigation runs its course. Close brackets. Paragraph 8.5. The allegations against the applicants are set out in the charge sheet, and the strength of the case is explained on page 7 to 10. It is the respondent's submission that these facts should be sufficient to find that the strength of the state's case support a verdict that bail be denied. Paragraph 9. The applicants declared that they have no intention to abscond and will stand their trial. In S v. Hudson, 1980, 4 SA 145D at 148, paragraph E to F, it was held that an accused who does have the intention to abscond is hardly likely to admit it, and that implied reliance cannot be placed on the mere ipse dixit of the accused. With regard to applicant 1 and 2, paragraph 9.1, in accordance to the provisions of Section 60, subsection 4, read with Section 4, subsection B, and 6, subsection 8 to J, A8 to J of the Act, the Court might take into account several factors to establish whether there is a likelihood that the applicants will attempt to evade their trial. In answer to the applicant's ipse dixit, the State placed the following on record, paragraph 9.1.1. The first and second applicants does not have sufficient family and emotional ties to South Africa as, Roman 1, the family members are provided by counsel at the last page of Exhibit H. Only lists 2 people. That was A, Mr. Zgambo Duncan Kwambo, a Malawian resident with a relative's visa spouse, valid from the 3rd of December 2019, last year, and expiry date of the 2nd of December 2021. The second person's particulars was Kate Ngwamba Mnyere, a Malawian citizen with visitor's visa, valid from the 11th of October 2020 until the 10th of November 2020. None of the 2 family members' relationship to the applicants are stated in the mail or documentation. Further, on neither persons with domicile in South Africa, and no evidence exists that their presence will ensure that the first and second applicants sojourn in South Africa till the finalization of this case. Romans 2. The first and second applicants' occupational ties to South Africa is of such a nature that enable them to reach the congregants or their followers as prophet and prophetess from anywhere in the world via the modern technology. Paragraph 9.1.2, Romans 1. Their assets in South Africa has been alienated and or registered under company names or other individuals or smuggled from the country. For that, see Exhibit M at page 27 to 29. The immovable property, sparkling waters, is attached as security for debt. to the already read out amount, this enormous debt will most definitely be a greater motivation to leave the country than to stay. The house in midstream is currently rented out and will therefore not be a loss if they abscond. Romans 2. The first and second applicants declared property and interest in Malawi, and the state showed foreign businesses interest in foreign countries. See Exhibit M at page 26 and 27. This can be a motivation to leave the country. There I refer to State versus Lethuania. It's a 1997 decision, 11 BCLR 1581 W at 1594 paragraph B. Paragraph 9.1.3 Romans 1. The applicants are self-proclaimed millionaires and can afford to forfeit the amount of bail, no matter what the monetary value thereof. Paragraph 2. The dictum at Atkin and another versus Attorney General of Zimbabwe. My apologies for that, misspelled Zimbabwe. 1992 2. SICR 296 ZS. Vida de Toy. Commentary on the Criminal Procedure Act 2019 at a 9-41 fines application. Bail was denied where Gobai CJ relied on the fact that the appellants, as multimillionaires with assets outside Zimbabwe, had the potential ability to cross the border into a country which had no extradition treaty with Zimbabwe. Romans 1 of paragraph 9.1.4. The strength of the case and the gravity of the punishment which is likely to be imposed if the applicants are convicted is of such a nature that it might motivate them to not stand their trial. Romans 2. With that said, it is important to place on record that the facts tendered during the bail application, the first and second applicants' application to the Specialized Commercial Crime Court, case number 11124 of 2019, cannot be compared to this case. Although I was not the assigned prosecutor to the case during the bail application, the transcripts show that the applicants were arrested for money laundering, fraud, and contravention of the Reserve Bank Act. The prejudice to the fraud pertained to fraudulent documents provided to the South African Reserve Bank on a query to purchase the purchase of an aircraft with foreign currency that was 1.25 million US dollars. Romans 3. Amended charges were leveled against the applicants in the indictment served on them on the 29th of November 2019, as investigation revealed contraventions of the Immigration Act. From there, the letter in terms of Section 48 of the Immigration Act stating its intention to withdraw the Bushiri's family permanent residence status that was handed up as Exhibit B and it finds application. The court is once again referred to page 17 of the High Court order in brackets. In the present matter, the DHA is not prevented from exercising a statutory function. There is no interdict sought against the DHA proceeding in toto. What is sought is an interdict of temporary nature, and ultimately the applicant will have to answer to the allegations made in the notice. Close brackets. Roman 5. The evidence pertaining to assets as set out in Exhibit M also differentiate the state's position on bail from that taken a year ago. Paragraph 9.1.5 Romans 1. The applicant's travel documents were confiscated by the SABC during the aforementioned arrest in 2019. But it is the respondent's submission that the absence of travel documents is no guarantee that the applicants will not evade their trial. That is based on the verdict in S versus Vermaas 1996 1 SICR 528T at 539 E2F. In brackets, the lack of travel documents will not deter anybody who is really serious to skip the country. These documents can be readily obtained. As well as S versus Novella. It's an unreported Western Cape case number 8340 of 16, handed down on the 12th of October 2016, in brackets. The retention of the appellant's travel documents is also of cold comfort, as the lack of travel documents in recent times is hardly a deterrent to persons who are serious and have the means to skip the country. Romans 2. Their first and second applicants have immense support and following in South Africa as well as neighboring countries. Several interviews with followers outside court prove their support and willingness to do anything for them. This fact will make it possible for the applicants not to stand their trial if they so wish to. In State versus Van Wyk, a 2005 case, 1 SICR 41 at 11, in brackets, the appellant had a passport. This reference is in Afrikaans. Die appellant het 'n paspoort wat hy aangebied het om in te handig, maar hy hoef natuurlik nie oor see of buite die landsgrense te gaan om sy verhoor te ontvlug nie. Hy kan eenvoudig binnelands verdwyn. Iets wat histories nie vergesog is nie. Volgens die ondersoekbeampte bestaan daar 'n sterk infrastruktuur van simpatiseerders en ondersteuners wat voortvlugtendes kan beskerm, huisves en onbetaald versteek. Romans 3. With reference to Exhibit Y, it is common cause that the applicants were, that is the DIRCO letter, the applicants were issued with a Malawian diplomatic passport. What is at issue is that they are within South African border, according to DIRCO, not afforded any diplomatic privileges. The applicants can therefore not claim diplomatic status and refuse their person and luggage to be searched at any South African port of entry. With regard to the third applicant, paragraph 9.2, with regard to the legal arguments pertaining to section 64, read with section 4, subsection B, and 6, subsection A to J, the respondent will rely on the same set out in paragraph 9.1 supra. Paragraph 9.2.1, the third applicant provided 3 addresses as set out in paragraph 7.3 supra. It is her declaration that she has no children but married and caring for her mother. Romans 1. The fact that she traveled to visit her husband in Cape Town is of concern, as the address provided and attested to in Exhibit K and W is an address verified by SABC. For that, see Exhibit M, Annexure JM2. Although the property is their registered address, evidence show that it is leased to Zimbabwe nationals. Romans 2. The applicant's mother reside at the property in Craigavon Park, Fourways, and according to her affidavit marked as JM3 to Exhibit M, only paid by the applicant and her husband. Romans 3. The proof of deeds to the properties does not guarantee that the applicant can be monitored or released on bail or traced should she abscond. Paragraph 9.2. That should read 2. I'm sorry, my numbering is not correct there. The assets are duly owned by the applicant and her husband, and if she would elect not to stand her trial, no harm would come to it. Paragraph 9.2.3 then. With regard to the factors listed in section 60, subsection 6C to J, the respondent rely on the same arguments set out in paragraph 9.1, 3 to 5. With regard to the fourth applicant, the merits of the fourth applicant's bail application was already argued before the Honourable Court, and I furthermore rely on the legal arguments set out in the heads of the argument supra. Paragraph 10. The respondent's submission with regard to Exhibit N is that it is irrelevant and of, it is my submission that it is relevant and of concern in adjudicating the question whether the applicants have shown that it is in the interest of justice for their release on bail. The affidavit attests to the fact that 5 case dockets wherein the applicants are identified as suspects are investigated. Similar to the current case, the complainants also invested in investment scheme, now known as Bushiri Investments, operated by the applicants, and the modus operandi is also similar. Paragraph 11. With all the evidence adjudicated as a whole, it is the respondent's humble submission that the applicant should not be successful in the application, as the interest of justice does not permit their release on bail. That was electronically signed yesterday, the first day of November 2020. Worship, with regard to further address, the state is once
Before
again...
you proceed, Counsel, what about paragraph 11? You didn't read the rest of paragraph 11.
The court's, sorry, that is the, that was my problem with my computer. copy that was printed by my colleague is the first one that I sent at just before 10. With the court's permission, can I just have a moment and look it up on my phone? I apologize.
Maybe I can assist my learned friend.
Please.
Paragraph 11 should not be there. She's indeed correct.
Yeah, that's the.
So it's not supposed to be here.
I will read it into the record, Your Worship.
Now tell me, are you including paragraph 11 or is it excluded in this heads of argument?
The second head of arguments that was forwarded at just
Please fix
after
my copy.
11,
There it is.
that's the one that I was supposed to. That's the only difference between the two sets.
Just fix it. Delete whatever is not supposed to go into the record.
Bishop will see that paragraph 10 on the part that I just read in is there, and then I just added 11, and then the second heads of argument that was forwarded as the correct ones has in it paragraph 12. So I'm reading into it paragraph 11. With the court's permission, Your Worship, with reference to the provisions of section 64C, read with section 60 subsection 7, it is still the respondent's submission that the applicants with special reference to the first and second applicants have demonstrated that they have the influence and capacity to attend to or influence or intimidate the witnesses in this case. All the complainants supplied their personal and bank details when they invested in the Ponzi scheme. Furthermore, most of the complainants and investors listed in the bank details are members and or attendees of ECG Church. The fact that legal representatives of applicants first, second and third are the attorneys of record of the complainants on the current case as well as linked MCS investment scheme will cause an easy avenue for intimidation and bribery of known and possible complainants. The content of page 12 to 14 of Exhibit M has reference. The nature of the first applicant's statue within ECG as their spiritual father and guide places him in a unique position to influence and manipulate complainants in this case. With that reference to Jim Jones at Jonestown in USA. Then paragraph 12 will follow. With all the evidence adjudicated as a whole, it is the respondent's humble submission that the applicant should not be successful in their application as the interest of justice does not permit their release on bail. My apologies, Your Worship. That is my official heads of argument.
Anything you wish to add? Are you done with your argument?
Yes, I
counsel?
do not wish to add anything else other than if the court has any questions.
Right, please substantiate your response. According to the defense, they've argued that when accused number 4 and 5 appeared at the Commercial Crimes Court, most of what you are saying is an opposition. Those factors already existed there. Why is it that you didn't oppose bail when they appeared in the Commercial Crimes Court and now still faced with the same set of facts, but now suddenly you are opposing bail? What is the difference between the two? Why now?
Bishop, I was not party to that appearance. I was not the assigned prosecutor. But from the record, it was clear that and when one looks at the heads of the application brought by the first and second applicants in that case, the state at that point was satisfied that they had PR status and that they had fixed addresses and that the list of movable assets was in line with what the state was aware of. It is However, Your Worship, the state submission that their PR status is under query by the DHA. I also submitted in my heads of argument, Your Worship, that between the February 2019 appearance where bail was fixed and now there was further investigation, which led to the institution of Immigration Act offences in that case that was now transferred to the High Court. The indictment contains Immigration Act contraventions, wherein it is stated that accused number 2 entered the country with a falsified exemption permit, and accused number 1 made incorrect statements in his application, and that there was a problem with the required medical evidence and scans that's required when in their application. So that was investigated, and that was why charges were added since the 2019 February appearance where bail was set. It is also the state submission, Your Worship, if one looks at the content of the affidavit handed in as Exhibit M, that the fixed property doesn't have the same value with regard to a bail application as it had in 2019, and that some of the movable properties has been either sold or placed in the name of other entities or companies, as well as vehicles that was removed.
All right, the bail application, they're continuing. The Bushiris and the co-accused, they are facing charges of fraud and money laundering amounting to 102 million rand and contravening the Prevention of Organised Crimes Act. We'll leave it there for now.